All right. I guess we should discuss in some extent what's going on lately with the Supreme Court, and in particular the last Thursday's Senate confirmation hearing, which was broadcast live and watched by as many Americans as watched the Super Bowl and other big events. It's one of those events that captivated the nation's interest. But my question to you, as somebody who's made a career on the Supreme Court, is this the best we can do as far as a confirmation process where we have this very political process where everybody sort of gets into their camps, and this is a drama that's played out almost like a soap opera on television?
No, I don't think it's the best we can do. We certainly ought to be able to do better, because it's an issue of credibility that should be resolved on its merits, not on the basis of political speeches back and forth. I should explain that with regard to Judge Kavanaugh, that I have a picture of him in my book. I've written a book called 6 Amendments, in which I recommend 6 changes in our fundamental law. And one of them is to reverse the Citizens United case, which allows unlimited political contributions to candidates. And I still feel, as apparently some of you do, that my dissent had the right in that particular debate. But in my book, I described some of the reasons for the rule that I think should apply, and which really did apply for many, many years before that case. And in that discussion, I describe an opinion written by Judge Kavanaugh on that very issue. The issue in the case was whether a Canadian citizen and a citizen of Israel who were living in New York temporarily could make expenditures in elections that were going on at the time. And right following Citizens United, they brought a proceeding in the federal court asking for an injunction against enforcing the statute that prohibits expenditures by foreign citizens in American elections. And Judge Kavanaugh wrote the opinion upholding the statute and holding that they could be barred from giving contributions to an American election. And I thought that he wrote a very persuasive opinion, and as a matter of fact, I put his picture in the book to illustrate my admiration for it. And one of the cases that he cited in that opinion was my dissent in Citizens United, which I thought showed the fact that he was a very good judge, had very good, very good taste in cases to follow. And I forget what the point I was going to but in any event, so at that time, I thought he had definitely the qualifications for to sit on the Supreme Court and should be confirmed if he was ever selected. But I've changed my views for reasons that have really no relationship to his intellectual ability or his record as a federal judge. He's a fine federal judge, and he should have been confirmed when he was nominated. But I think that his performance during the hearings caused me to change my mind. I think there's several commentators, Larry Tribe among them, who's a constitutional law professor at Harvard, have written pieces in which they suggest that he has demonstrated a potential bias involving enough potential litigants before the court that he would not be able to perform his full responsibilities. And I think there's merit in that criticism, and that the senators should really pay attention to it for the good of the court, it's not healthy to get a new justice that can only do a part-time job. And
How is that different from the Clarence Thomas case? You were there after Clarence Thomas had a very bruising confirmation session hearings in 1991 and came on the court. How did the other justices react to that in the fact that you had somebody who was a polarizing figure in a body of people who were basically a collegial group of people?
Well, there are a lot of differences between that. First of all, there's nothing that Clarence did in the hearings that disqualified him from sitting in cases after he came on the court. Secondly, I really don't remember any conflict in the testimony between him and Anita Hill. I think you could believe everything she said and think he may have acted unwisely and improperly to her without saying he would be disqualified from acting as an impartial judge or an honest judge. And he turned out to be, I disagree with him on most of his important rulings, but as a person, I'm very fond of him. He's a very, very decent, likable person, and you cannot help but like Clarence Thomas, which I don't think necessarily would be true of this particular nominee.
You watched the hearings, and people who had watched them and followed his explanations of things in his yearbook have noted that some of the things that he said under oath were some level of being evasive or not true. Is that in itself disqualifying when you swear to tell the truth before a congressional committee and get a number of facts wrong or mischaracterized?
Well, I'm not aware of any facts that he got wrong, that Clarence got wrong.
Well, oh, no, not Clarence. I'm talking about Justice Kavanaugh, or Judge Kavanaugh.
Oh, I'm sorry. Well, it is an important fact, yes.
Is it disqualifying?
Well, not necessarily, I don't know, but I would think in this case, there are enough people who've been put in categories for which he would be unable to sit as a judge that he really should not be.
Okay.